everyone, and welcome to the daily newspaper analysis, which is brought to you by LawSikho. So today we have an editorial for our discussion that we have taken from the Indian Express. The title of this article is Court versus Court, and herein we'll be discussing the tussle on the Saibaba case that we will be witnessing between the Bombay High Court and the Supreme Court of India. Then we have news update and legal news for the day. So the Bombay High Court recently acquitted GN Saibaba within a well-written and exhaustive order. However, the Supreme Court has swiftly come forward upon the same in the matter of the accused, who had already served more than 7 years. So basically, there is a tussle of decision between the Bombay High Court and the Supreme Court of India. And the case exactly in brief, if we were to discuss, is that Saibaba, GN Saibaba, was charged with terrorism and criminal conspiracy in 2017 under the UAPA, that is the Unlawful Activities Prevention Act, and it was alleged that he had links with the Maoists. So under the charges of UAPA, he was being tried by the trial court, but later he has been now acquitted by the Bombay High Court, but the Supreme Court has a completely different contention in this regard. So let's firstly, on one hand, understand that what is the High Court verdict, that is the Bombay High Court verdict. So the High Court judgment had two core findings. Firstly, that the cognizance was taken by the trial court without sanction being granted, or which basically the permission being granted by the sanctioning authority, as it is required under the UAPA Section 45 Clause 1. So this was not there, and that is why there is a lacuna over here. Secondly, the issue has been raised by the Bombay High Court was that an independent authority had not reviewed the prosecution evidence as laid down under the provisions of Section 45 Clause 2 of the UAPA Act. So there were two legal drawbacks and the legal steps that were not taken care of, and that is why Bombay High Court believed that the case was not that strong. So the Bombay High Court has also held that the exhaustive inquiry in the evidence gathered was laconic, which means it was lacking since it contained only 6 lines. A report contains conclusion sans reasoning, and that is why no real case could be found on those grounds. But on the contrary, let's see what actions have been taken by the Supreme Court, or what contention does the Supreme Court of India hold in this regard. The Supreme Court has stated that the Bombay High Court in this case has not taken into account the merits of the case and judgment that were given due consideration by the learned trial court, and they have completely overlooked upon the same. Secondly, the Supreme Court held that the Bombay High Court did not consider important facts and questions of law that had not been considered, and definitely there is an overlooking over here to be seen. And thirdly, it is astonishing to see that the Supreme Court decided to stay the acquittal of GN Saibaba over a question of law when the Supreme Court did not find any other issues with the Bombay High Court judgment. So basically, there is no clarity as such when it comes to, even if we talk about the Bombay High Court judgment or the Supreme Court overview about this, because there is no clarity as to what really were the merits of the case, and thus a deeper intervention and a deeper looking into this matter needs to be done. With this, let's see what do we have for news updates today. Firstly, Coal India to set up a 1190 megawatt solar power plant. So as part of its diversification program for clean coal energy, Coal India Limited signed a memorandum of understanding with Rajasthan Vidyut Utpadan Nigam Limited for developing a solar power project of 1190 megawatt production capacity in the state of Rajasthan. Secondly, Logistics Performance Index 2022. So Andhra Pradesh, Assam and Gujarat are the 3 of the 15 states and union territories that are categorized as achievers in the Logistics Index chart of 2022, according to a study released by the Commerce and Industry Ministry. So the Logistics Performance Index 2022 measures the effectiveness of the logistical services required to encourage exports and economic expansion, be it the infrastructure, the paperwork, etc. Thirdly, Power Exercise 2022, cybersecurity exercise called as Power X, was designed and organized jointly by Indian Computer Emergency Response Team, that is CERT-IN, that takes care of the cybersecurity threats as well as cybersecurity in the country, and Power CSIRT, that is the Computer Security Incident Response Teams in Power Sector. The exercise was hosted in a simulation platform, and the event witnessed the participation of more than 350 officials from various power sector utilities. Fourthly, Women's IPL. So the long-awaited Women's Indian Premier League is set to become a reality, with the BCCI planning a 5-team tournament for March 2023, immediately after the Women's T20 World Cup ends in South Africa on February 26th. The BCCI's proposal plan involves a total of 22 matches, with each squad comprising 18 players with a maximum of 6 from overseas. No more than 5 overseas players can feature in a playing 11. Let's see what do we have for legal updates today. Firstly, National Green Tribunal on Doodh Ganga pollution. So the principal bench of the National Green Tribunal has imposed a penalty of rupees 35 crores on the Jammu and Kashmir administration for failing to prevent the discharge of untreated sewage into the Doodh Ganga, which is a major tributary of River Jhelum. This is another very important question for your GK exam as well. So if you're preparing for static GK as well, it can be very well asked as to Doodh Ganga is a tributary of which river, and we might very conveniently mark Ganga or maybe Yamuna as the answer, but please remember Jhelum is the correct answer over here, and Mamath in Kashmir's Valley, Srinagar and Budgam districts. This was held in the case of Raja Muzaffar Bhat versus Union of India and others. Here is an important question for you all. Do you know where is the principal bench of the National Green Tribunal? If you know the answer, pause this video right now and let me know in the comment section below. Secondly, limitation co-counter claim stops on the date of notice of arbitration, says the Madras High Court. So the High Court of Madras has held that the limitation period counter claims would be arrested on the date on which the respondent issues the notice of arbitration, and the date of filing of counterclaims would be irrelevant. The bench also held that limitation is a facet of public policy. This was held in the case of Chennai Water Desalination Limited versus Chennai Metropolitan Water Supply and Sewerage Board. So this was all for today. We hope you liked the session. Thank you so much for staying tuned with LawSikho. If you wish to download the PDF of today's slides, you can join our Telegram channel. The link is there in the description box below, or you can also scan this QR code that you can see on your screens right now. Thank you so much.